Creating different classes of shares gives you more control and flexibility over running your company. But how do we actually go about creating these different classes of shares, and what must we do to be compliant with the relevant laws? In this video, we'll discuss how to actually create different classes of shares in compliance with the UK's Companies Act 2006. I'll be sharing my screen and showing you what I've done for previous clients of mine to create different classes of shares, and I'll take you step by step through the entire process. I'll also link in the description below, completely free, a step-by-step guide that takes you through the process alongside all the templates that you need to create different classes of shares. Amazing. Now, before we get started, let me just very quickly introduce myself. I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm. And on YouTube, my goal is to make business law easy. Make sure to stay until the end of the video to find out why you may want to have a shareholders agreement in place and what issues to avoid when drafting your shareholders agreement. Amazing. Let's get started. So you should now be able to see my screen. This is the step-by-step guide that we need to follow. The first step is to draft the applications for the shareholders asking to be issued these different classes of shares. As you can see here, I'm making reference to document A, which is this one right here. Again, it's all linked in the description below, completely free for you to download right now. And the way this works, as usual, we just remove the square brackets and replace that information with your information. So as an example here, you would include your company's name. Amazing. Coming back to the step-by-step guide, we can now move on to step number 2, which is to draft an amended version of your articles of association. Now, if you already have bespoke articles, then you'll need to amend those. If you instead are using the model articles of association, meaning you've never uploaded or amended your articles, then I've linked here the government's website where you can download the model articles. These are it right here. Just as an expert tip, I like to include the different classes of shares in the model articles as a new article after Article 29 of the model articles of association. And what I like to do is start out with explaining in the articles what is the statement of capital of the company, so how many shares are there in the company for each different classes of shares, and then I like to build upon that by creating different articles for each of the share classes, explaining what the share class is like. So for example, does it have the right to vote, the right to dividends, does it have the right to tag along, and so on. Amazing. Now we can move on to step number 3, which is to draft the board minutes to approve the amended articles of association and to ask the shareholders of the company to allow us as the board of directors to issue and create these different classes of shares. Now, board minutes, which are the record of the decisions of the board of directors, are a legal requirement under the Companies Act 2006. And to make your compliance requirements easier to fulfill, I've linked document B below. This is what it looks like. And as always, you just need to replace the square brackets with your relevant information. As you can see here, I've given you the option to create 2 different classes of shares, A ordinary shares and B ordinary shares. Really, you can name them whatever you want, and you can create them to be whatever you want them to be. Coming back to the step-by-step guide, we can now move on to step number 4, which is to draft the written resolution for the shareholders to approve the relevant transactions. Now, you will need a special resolution, which means either 75% of the shareholders or 75% of the voting shares to be in favor of the resolutions. There are 2 main ways to go about getting shareholder consent. You can either do it at an actual meeting, known as an extraordinary general meeting of the shareholders. But in that case, you will need to serve notice to the shareholders, usually 21 days, wait for that time to elapse, and then have the meeting. A quicker and easier way to do it is to do it by written resolution, which is whereby you simply have a document and you give it to the shareholders who are present or send it to them via electronic signature and get them to sign it. And so long as the 75% threshold is met, then the resolution has passed. Again, to make things as easy as possible, I've linked document C. This is what document C looks like. As always, you know the drill. You will need to change the square brackets with your information. You have the different classes of shares here. As you can see here, it's making reference to the new articles of association. So in this square bracket here and in this one right here, you'll need to specify which article number of the articles of association deals with that specific class of shares. Just to very quickly clarify, for each of the shareholders that you have in your company, you'll want to create a space like this with their name and the ability for them to sign. Coming back to the step-by-step guide, we now need to draft the share certificates. Now, the share certificates are a great way to evidence title or ownership of shares. To make this as easy as possible, again, I've linked a document, a template. This is document D, and this is what a share certificate can look like. As always, replace the square brackets, and we come back to the step-by-step guide. Right, so what we've done until now is simply drafted the documents. We've prepared the documents in advance of the relevant meetings. Now that we have all of the documents ready, we can move on to actually enacting the procedure and starting with the board meeting, which is step number 6. We need to call a board meeting with the directors of the company. You might need to give notice in compliance with your articles of association. And at that board meeting, we'll need to vote on these specific resolutions, including, again, the adoption of the new articles of association that specify what the different classes of shares are and the authority to allot more shares of a different class. Now, whilst we're having the board meeting, we're not going to end the board meeting and then move on to the shareholders by signing the written resolution. Instead, during the board meeting, we're going to need to allow the shareholders to sign the written resolution. Ideally, they do it right there and then. Then we reconvene the board meeting. We confirm that enough shareholders have approved of the transactions, and then we bring the meeting to a close. Which brings us to step number 7, which is the shareholders sign that written resolution. Once enough have done that, we come back to step number 8 at the board meeting, and the chairman or chairperson signs the board minutes confirming that enough people have voted and the resolutions have been passed. Amazing. So what has happened now is that both the board of directors and the shareholders are in agreement with these resolutions. But now we actually need to issue these shares, and we go about it by giving the shareholders share certificates. And this is step number 9, which is you need to sign the share certificates and deliver them to the shareholders. Again, these are the share certificates. And coming back to the step-by-step guide, we also now need to update your company's statutory registers. Now, if you don't have your company's statutory registers, please do not worry, because it is unfortunately a very common practice to simply not have them. But it is unfortunately a mistake that tends to be caused by a lack of understanding or awareness of the fact that companies do really need to keep internal registers. And this is document E. This is what it looks like. It's simple spreadsheets that record important information about your company, such as who are the members in the register of members, who are the people with significant control, and who are the directors of your company. So, especially relevant here, you will need to add entries for the new shareholders holding the new classes of shares. Great, now we can finally move on to the last step, which is to file the following documents at Companies House. We have 3 main documents to file, or 3 main pieces of information. First is the written resolution of the shareholders, and this typically is uploaded to Companies House using this link right here and clicking on Start Now. And the same link is used to also upload your new amended Articles of Association. Once you've done these 2, we can then log in into your web filing account, and at the top right of your account, you will see all forms. You'll want to click on that and select form SH01. Amazing, you have successfully created a different class of shares in compliance with the Companies Act 2006. You're amongst the few who are actually compliant in their practice. Now, before we move on to discussing why you would need a shareholders agreement and what issues to avoid when drafting that shareholders agreement, make sure to subscribe to my channel to continue to receive pragmatic, practical and to the point legal information and templates. Also, if you want professional legal advice from a qualified solicitor, make sure to reach out. I have my contact details linked below. And keep in mind that I do completely free legal advice calls at any time, so simply reach out. Now, since you're issuing different classes of shares, it's very likely that you're not just a one-person company. You'll have different shareholders in your company. And that means that typically you should at least consider strongly having a shareholders agreement in place. The shareholders agreement helps you clarify the shareholders' obligations and make sure that the company is looked after properly. Whilst drafting your shareholders agreement, first of all, I would advise you to seek independent legal advice and get a professional to draft it. But these are the top 3 issues to avoid. Number 1, you should include drag-along provisions. And drag-along provisions, put in simple terms, mean that if enough shareholders are willing to sell to a third party, then they can drag along and force everyone else in the company to also sell their shares to this third party. The reason why we have drag-along provisions is because maybe you, as the founder of the company, are bringing on smaller investors like minority shareholders, but your ambition is to one day sell to a private equity firm. And if that is the case, the private equity firm typically will want to buy the entire company. You don't want to jeopardize your deal by having minority shareholders who are not willing to sell their shares. The second issue that you want to avoid is not including a deed of adherence and not making an obligation for shareholders who are looking to sell their shares to a third party to ensure that that third party needs to sign the deed of adherence and adhere with the shareholders agreement. Let me explain. The deed of adherence, in short, is just a way for a new shareholder to agree to the existing shareholders agreement. And you want to ensure that if any current shareholder in the future wants to sell their shares, that new buyer will need to adhere by the existing shareholders agreement. And the third issue is not checking your articles of association against your bespoke shareholders agreement. You need to make sure that there are no conflicts, and if there are conflicts, you will need to amend your articles of association to avoid that happening. If you want to find out how to go about amending your articles of association in compliance with the Companies Act, make sure to watch this video right here. Thank you for watching.